It's time now for a look list in local news. In the news, WIFO on hand for District Attorney Keith Higgins' press conference regarding the John Yonkowski case and the Wendell Take Lawson case. It occurred yesterday at the Camden County Courthouse. Several media outlets on hand, credential media only. Wayne County Sheriff Chuck Mosley tried to attend the press conference but was denied access to the press conference. Sheriff of Wayne County, Chuck Mosley, not on the same page with the district attorney as the district attorney. A big part of his press conference yesterday was him stating that the lead investigator, Brad Kickletter, is not to be trusted and that he will not call him to testify in any criminal case from this point forward. He stated that in this John Yonkowski case that Brad Kickletter provided a cheat sheet of bullet points to the undercover officer for her to use in preparing her report. He says that Brad Kickletter falsely told the GBI that the medical director at the Valdosta lab told him that hydrocodone and oxycodone would test as the same substance in a blood test. Press conference was long. We'll have more on the press conference tomorrow's newscast, but we begin with the results of the GBI investigation into the case. As Special Agent with the GBI, Stacey Carson, was at the press conference, and she had these comments on the GBI investigation.
DA Higgins said, "My name is Stacey Carson. I'm the Special Agent in charge of the GBI Region 14 office in Kingsland, Georgia. On November the 13th, as DA Higgins stated, of 2023, we were asked by Wayne County Sheriff Chuck Mosley and DA Higgins to investigate allegations of rape and non-consensual drugging of women against John Yonkowski. The Wayne County Sheriff's Office provided us with a complete copy of their investigative file, and we reviewed it in its entirety. We conducted numerous interviews and investigative acts, and at the conclusion of our investigation, we were unable to establish probable cause to make any arrests." Thanks.
And again, those comments of Special Agent Stacey Carson with the GBI. Here were some of the district attorney's comments at the press conference, stating that he felt there was simply insufficient evidence to present to a grand jury.
With these charges from what had transpired at the Chop House, we were also presented with a subsequent charge of rape that was brought both against John Yonkowski and Weldon Lawson based upon a statement that Jan Wolgamuth made to the sheriff's office, I believe on June the 28th of 2023. What had transpired, as a little bit of background, is what happened at the Chop House became public knowledge once Mr. Yonkowski was arrested, and then other females started coming forward based upon the allegation that was made that he had drugged the undercover officer's drink. They came forward with their handwritten statements to indicate what had transpired with them. But looking at these criminal charges and applying our legal ethics that we're required to do so in the law to this case based upon the evidence, the law basically tells us that probable cause requires a probability less than a certainty, but more than a mere suspicion or possibility that an accused committed the crime. And proof beyond a reasonable doubt means that all essential elements of a case, including identity, must be proven beyond a reasonable doubt to the satisfaction of a fair-minded, impartial juror who is honestly seeking the truth. The evidence must exclude every reasonable theory or hypothesis except the defendant's guilt. So if there's any other way that something could happen other than the accused having committed the criminal act for which he is charged, that is not proof beyond a reasonable doubt. As I said before, identity, the person who committed the crime, even if you have evidence of a crime, you've got to prove who did it, and that has to be proven beyond a reasonable doubt. Facts and circumstances that place merely a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of guilt, are not sufficient to authorize a conviction, and mere presence doesn't get us there either. Mere presence is inadequate as well. So applying the rules of ethics, the principles of law, we then look at the evidence in the case. We look at the charges, and when you look at the charges of reckless conduct and distribution of a controlled substance, all of those are based upon an allegation that John Yonkowski drugged the undercover officer's drink. That's a specific material allegation with both of those charges. The sexual battery, there is a specific allegation with regard to sexual battery, alleging what transpired with regard to the female undercover officer, the Jesup police officer. A specific allegation of that is without her consent, and we will talk about that briefly in just a moment. And then we have criminal intent to commit rape, which is also based upon the allegation as the substantial step toward committing that crime is the allegation that Jankowski drugged the undercover officer's drink. So when we look at the warrants and the evidence in this particular case, there's no evidence to show that Jankowski put drugs in the officer's drink. None whatsoever. The undercover officer left her drink unattended on several occasions when she went to the restroom, when she left the table to go play darts. The officer does not know who put any substance in her drink. The two other undercover officers who were there as well never saw anything tamper with her drink. No one else saw anything take place with regard to that. The sheriff's office of Wayne County did not obtain any surveillance video from the chop house because by the time they took the time to go try to get it, it had already been recorded over. So there's no surveillance video that would show us what actually transpired inside the chop house on June 15.
Once again, those are some of the comments that District Attorney Keith Higgins in his press conference. Again, during his press conference, he gave a timeline dating back to John Jankowski's arrest back on June 23rd, but in his presentation simply ignored the 3 bond hearings that occurred in Wayne County Superior Court in which bond for John Jankowski was denied not once but twice. We questioned him about the bond hearings and the evidence that was presented in court by Assistant DA Tiffany Montenegro. You'll hear the question and the response by DA Higgins when we come back after this word from our sponsor, other commercial messages, so please stay tuned. We continue with more from the press conference Tuesday in Camden County held by District Attorney Keith Higgins. During his presentation, he mentioned that there's a false narrative that they had all these other written statements from other women who came forward after the John Jankowski arrest. Higgins said yesterday that's a false narrative, but it was Keith Higgins' Assistant DA Tiffany Montenegro who stood up in Wayne County Superior Court not once but twice, arguing that bond should be denied, and she waived the 11 sworn affidavits from women who had written statements saying that the same thing had happened to them. Again, we asked Keith Higgins about that yesterday and again asked him if Tiffany Montenegro, the Assistant DA, lied in court.
To my knowledge, she's still employed by the Wayne County Sheriff's Office, and I don't have a dog in that fight. My only consideration that as a representative of the state, as somebody who is calling witnesses and asking a jury or a finder of fact to believe that witness, I'm not going to call Brad Kicklighter based upon his credibility issues, and nor will any other assistant district attorney in this judicial circuit.
Concerning the GBI's investigation of this, if he provided you guys with obviously erroneous information, what's the GBI going to do at this point?
We provided our case file to DA Higgins. He's reviewed it, and any issues or concerns that we have addressed those with Chuck Mosley.
So at this point, the GBI no longer has any interest in Mr.
Our investigation did not focus on anything that Brad Kicklighter did.
Okay.
That's not right.
So just a second. I will say this, that a copy of this complete case file was provided to Sheriff Chuck Mosley prior to the date or around the date that it was provided to me. So he's had the opportunity to review all of this information and see the same things that I have.
Are there any charges going to be brought against Brad Kicklighter?
The matter is going to be referred to the Prosecuting Attorney's Council for review and make that determination.
Like I said, I want to go back. This case had 3 bond hearings, not 1, not 2, but 3. And in the first 2, your Assistant DA, Tiffany Montenegro, argued all this evidence, claimed she had all these written statements. That's when there's no false narrative. She's the one who presented that in open court in front of a Superior Court judge and got bond denied not once, but twice in front of a Superior Court judge. So the judge sided with her evidence, which was the state's evidence. So where did all the evidence disappear? Did she lie?
None of the evidence disappeared, and this entire case file, by the way, will be uploaded on the District Attorney's website hopefully today, this evening. It can be found at www.brunswickda.org, and you can look at it for yourself in terms of what are in the written statements. Now, with regard to, I have no idea what transpired at a bond hearing. I can tell you the issue with regard to a bond hearing doesn't usually get into the merits of the case and what the evidence was and what can be proven. At that point, we only know what the charges are. We've got warrants.
Did you have the transcripts of those bond hearings?
Well,
you heard what Tiffany Montenegro presented.
Well, actually, I don't. But with regard to bond, with regard to bond hearings, bond hearings are with regard to whether or not an individual, determining whether or not an individual can be released on bond based upon certain factors in the law, whether or not they are likely to commit another felony or crime if released on bond, whether or not they're likely to flee the jurisdiction and not appear in court, whether or not they pose a threat to the public, etc. So at that particular time, we do not have a complete investigative case file from the sheriff's office. We have warrants, we have a partial file, if anything. We may have handwritten statements. We are basing our request to deny bond based upon the nature of the charge itself. And whatever the individual's criminal history may be. So a bond hearing is not an assessment of the evidence in a case. It isn't. And if you know, and so there are generally not a court reporter present at bond hearings in magistrate court. And with regard to that,
now this was in Superior Court. There was a court reporter.
Okay.
And she presented the state's evidence that came from your office. She worked for you. And
actually, the evidence, Bob, would not have come from my office. The evidence that we have is whatever the sheriff's office gives us. And we are dependent, if I may finish my answer, Bob, I'd appreciate it if you'd be civil with me.
I'm civil, I'm just saying
The evidence in the case comes from the sheriff's office or the investigating police agency. We are dependent upon them to provide information to us. The only information we have to provide to the court is what the sheriff's office has provided to us. So with regard to that, the issues at a bond hearing are not pertaining to the merits of the case, whether or not it can be proven, not even whether or not there's probable cause to support it. That's addressed at a preliminary hearing. A bond hearing addresses legal issues with regard to an individual, whether or not they should be granted a bond pending trial based upon other factors with regard to their nature, the nature of the crime alleged, not the proof involved in it, but the nature of the crime alleged and the nature of the individual with regard to his criminal history or lack thereof, his ties to the community or lack thereof. So the issues at a bond hearing are totally separate and unrelated to what is addressed at a preliminary hearing.
And once again, those comments of District Attorney Keith Higgins. Once again, we'll have more tomorrow on this story and more from the press conference. As now the story is, what is the fate of lead detective Brad Kickletter at the Wayne County Sheriff's Department? District Attorney Keith Higgins says he has no credibility and will not be allowed to testify on any case he worked on. And they state that could affect close to 40 cases here in Wayne County. Sheriff Mosley disagrees with the DA's assessment, is expected to make a statement today. We'll have more from the DA on his thoughts on Brad Kickletter tomorrow on the local news. But again, a recap, the case against John Yonkowski and Wendell Tank Lawson will not be pursued any further by the District Attorney's Office. Charges have been dropped, and any case Brad Kickletter worked on is in deep jeopardy of being dropped as well. We'll come back with some final news notes after this word from our sponsor, the commercial messages, so please stay tuned. Final news to the news, the Wayne County Commissioners met Monday. After an executive session, Chairman Mike Gordon made an announcement that information from county executive sessions have been leaked. He says it'll be addressed and the problem will be remedied. No other details were given, and we'll continue to follow that story as it develops. City of Jesup has a full-time city manager, as Nick Ellis reported last night, as the city's full-time city manager. Jesup Police Chief Chris Hamilton announces that on Easter Sunday, officers were dispatched at the intersection of Walker and Whaley Street in reference to a fight and someone shooting. Officers arrived on scene and were told by several people that a person fired gunshots in the air and they were run off from the area. Later, officers received a call from dispatch informing them of a gunshot victim who had arrived at Wayne Memorial Hospital in a personal vehicle. The victim, who had sustained a gunshot wound to the leg, claimed to have been shot while walking up to attend the block party on Walker Street. However, he was unable to identify the person who shot him, has not offered any additional information. In response, officers revisited the area where the victim stated the incident occurred. After multiple interviews with individuals and a thorough search of the area, no evidence pertaining to the shooting was found. Jesup PD is investigating the incident and urges anyone with information to come forward. If you have information regarding the incident, they ask you to please contact the Jesup PD at 912-427-1300. Finally, in the news, the community-wide blood drive set for Monday, April 15th from 1 to 6 p.m. Again, to make an appointment, they ask you to visit redcrossblood.org, enter Jesup. Again, the blood drive set for Calvary Baptist Church Gymnasium on Monday, April 15th from 1 to 6 p.m. That's going to do it for latest in local news. Sports comes your way in a few minutes. Bob Morgan, have a great day.